Firstly, it's a genuine honour to be invited to speak at this conference, auspiced by a centre set up in the name of the great Ron Castan, such a remarkable advocate for human rights and human dignity of people. Now, it's true, as the introduction disclosed, that I work as a lawyer and director with refugees, but today I'm not going to talk about refugee law, well, not primarily. I want to address a bigger overarching question, which is ultimately about the kind of society that we want to live in and to defend. It's about one of the golden threads of the fair, just and good society, our commitment to the rule of law. And it's about the related question, which I will call the ethics of protection, about why the law and morality matter and about what's at stake. On this point, let me start with a story in three parts, stories that have been extensively reported publicly. In May 2010, a Sri Lankan Tamil woman and her two young boys, aged 4 and 6, arrived by boat in Australia seeking protection as refugees. Initially, they were detained on Christmas Island. They were moved to alternative places of detention in Leonora, Western Australia, and then Inverbrackie in South Australia. And later, they were moved into community detention and were allowed to move freely in the Australian community, subject to conditions such as regular reporting. The mother and her children were found to be refugees by the Department of Immigration. About 6 months later, in March last year, they moved to Melbourne to live with the mother's then de facto and now husband. Less than 2 months later, the woman and her two children were transferred from the community setting in the suburbs of Melbourne to the detention facility at Sydney Immigration Residential Housing in Villawood. The detention facility at Sydney Immigration Residential Housing in Villawood. She was told that this move was because she had been assessed by ASIO to be a risk to national security. She was not told, and did not know why she was deemed a risk. She was not charged with any offence, and she has remained there since in Sydney Immigration Residential Housing in Villawood for well over a year, and recently gave birth to a baby boy who is an Australian citizen. Her two eldest sons were later granted protection visas and have become permanent residents. And although her 3 sons have visas or citizenship and are allowed to live in the community, they live in the detention facility as visitors so that they can be with their mum. Beyond a sanitised summary of reasons provided since, she has never been told the information on which she has been deemed a risk to national security. She has never been charged, never been tried, never been convicted of any offence. She remains detained, apparently indefinitely, and possibly for the rest of her life. This mother may be familiar to you. Her name is Ranjini. Now, while Ranjini's fate was unfolding, on 16 May 2011, a mother and her 4-year-old son, ethnic Kurds fleeing persecution in Iran, arrived by boat in Australia. The woman's husband, the child's father, had arrived in Australia 18 months earlier and had been found to be a refugee. Usually this would entitle family reunion in Australia, but not so here. The mother and little boy had the misfortune of having arrived after the announcement of the Malaysia solution, though before its formal signing. At this point, they were part of a group of 274 asylum seekers marked for expulsion to Malaysia or elsewhere. The government had insisted there would be no exceptions. Children would not be spared. The mother and child remained incarcerated on Christmas Island. The husband remained detained in Maribyrnong in Melbourne. We wrote to the government soon after, asserting the mother's and the boys' rights to refugee protection and family reunion in Australia. We also outlined the distress and anguish being experienced by the mother and by the boy, who was desperate to see his dad. The government's written response dispelled any hope of the humanitarian exception. It stated that people arriving by boat, called irregular maritime arrivals, who had arrived after 7 May would not have their claims processed in Australia. And for the family, the response in writing said this, and I quote, "They," it's the mother and the son, "they continue to be detained for the purpose of removal to another country." A difference of 10 days in arrival was to be the difference between reuniting with the husband and father and being consigned to an uncertain fate of forced family separation somewhere else. A week later, we issued a High Court challenge, which in essence sought to stop the government from permanently splitting up this family who were trying to reunite and to live together in safety. The core argument was that under Australian and international law, the right to family reunity for refugees required that the government recognise the mother and son as refugees and allow them to stay and be protected due to the situation and status of the husband. The government later settled the case, and the mother and her son were granted protection in Australia. The case is known, by the way, as M54. While the case was on foot, the government agreed to stay the expulsion of any other people who arrived by boat after May 7. But that's how close this mother and child, and many others in a similar situation, came to facing forced separation in a country like Malaysia with a long-standing track record of serious mistreatment of refugees. Now, 2 months later, in August 2011, I was cooking for the family on an early Saturday evening at my home in inner city Melbourne when I received another call for help. It was a distress call from a group of men incarcerated on Christmas Island wanting advice. These men, some of them from Afghanistan, feared being expelled to Malaysia. Later that evening, I spoke by phone with some of the Afghan men seeking help, and they were petrified. They explained through the aid of interpreters that they'd recently arrived by boat in Australia seeking protection, only then to be told by Australian officials that they would not be allowed to seek protection as refugees in Australia. Instead, they were to be expelled to Malaysia, where they feared suffering more brutality and then deportation from Malaysia to life-threatening harm in their homelands. Separately detained on another part of Christmas Island were women and unaccompanied children, and they too, I was told, wanted legal help. That evening, my attempts to speak with them were blocked by the Department of Immigration. I was told by the Department of Immigration that they were on alert, unquote. I said, alert for what? I was told, oh, well, if anyone says the word lawyer. My attempts that evening to speak with the women and unaccompanied children failed, and 6 unaccompanied children only were able to join the High Court proceeding because later one of the men that I spoke with, who became the lead plaintiff in the High Court case, remembered some of their names from the boat journey and agreed to be their litigation guardian. Their actual guardian at all times, of course, was the Immigration Minister. Within 24 hours at 6 p.m. on Sunday evening, we were before the High Court of Australia in Melbourne, where an urgent injunction was granted to stop the government from expelling any of our clients to Malaysia. And it's here that we learnt that 16 of the men were to be put on a plane at 11:30 a.m. the next morning on Monday morning. The court granted an interim injunction which was extended the next day pending the full determination of the matter. But that's how close these people came to losing their rights. And when you think about what's at stake, no less than life or liberty, no less than protection from brutal abuse, it reminds us, I think, of how precarious access to lawyers and the law can be in this country. About 3 weeks later, the High Court emphatically ruled by a majority of 6-1 that the government's proposed expulsion of these people to Malaysia was unlawful and prohibited, principally because Malaysia was not bound by international or domestic law to process or protect refugees. These very vulnerable people, so for these very vulnerable people who are unlikely to have ever had anyone independent, let alone the law, spring to their defence through the trauma of their pasts, the sense of relief was deep and overwhelming. And so was their sense of empowerment. Now, to understand the context of the High Court challenge and where we are now, we must rewind just over a decade to the time of the Tampa. As we all know, 433 asylum seekers en route to Australia were refused entry and excluded from applying for protection under Australian law and were instead expelled to Nauru for processing of claims and human warehousing. This was done under laws enacted by Parliament during the Tampa crisis in 2001, the same laws which were the subject of the Malaysia case in 2011. The policy was driven by a determination to deter people coming by boat who were seen as having arrived by way of what was called secondary movement, a term otherwise less fortunately referred to by some as queue jumping. The idea was that having jumped a queue, taken, if you like, an unfair advantage, and having managed to get here, they could be and should be penalised, punished. The fact that there were and still are no real queues and no real protections accessible en route to Australia didn't get in the way of prosecuting this policy. Nor do these facts seem to have stopped last year's so-named expert panel on asylum seekers recommending a so-called no advantage principle for asylum seekers who come here by boat. A recommendation adopted by government as policy, and a policy which imagines an average waiting time for refugee resettlement in our region as the basis for determining how long someone is left languishing on Nauru, when the UN Refugee Agency, the experts in this area, say that the very assumption is wrong and that no such average exists. A policy still in search of a benchmark, and a policy which has done nothing to discourage perpetuation of perhaps the most toxic myth in the refugee area, queues and queue jumping. A policy which bears no resemblance at all to fundamental and long-established international principles and practice in the refugee arena, and a policy which in effect proposes to punish the very people we're meant to be protecting under our international treaty commitments. Now, in the wake of the government's PNG plan announced last week, the fate of the no advantage test remains unclear. Has no advantage been replaced by no chance? Replaced not just on billboards and in sound bites, but in what informs the policy towards spontaneous asylum seeker boat arrivals. Whether the PNG plan represents more than a temporary device to increase severity on the scale of punishment for people who, by boat, seek freedom from abuse is as yet uncertain. Now, as many of you in this room will be painfully aware, history has shown that the practice of Pacific expulsion imposed severe and enduring harm on a mass scale to so many innocent people. And yet, amidst the interminable political jousting over who can devise the harsher policy toward a vulnerable people seeking safety, we have witnessed, I think, a most strange revisionism which somehow recasts the Nauru and PNG plans as humane, or at least almost inexorably and empirically proven as necessary to revive. In my judgment, this displays a disturbing disregard for the overwhelming evidence of the deep inhumanity and damage wrought by the previous experiment. Damage determined by the policy driving it all, deterrence, stopping the boats, and consciously punishing those people who managed to get here. It recalls the words of the late great historian Eric Hobsbawm when he wrote, and I quote, "The destruction of the past is one of the most characteristic and eerie phenomena of the late 20th century. We live now in a sort of permanent present, lacking any organic relation to the public past of the times we live in." Well, the past speaks to the present for me, and I can assure you that during my work in Nauru, in the dying days of the Pacific Solution Mark I in 2006 and 2007, representing refugees, I saw firsthand unaccompanied children and grown men alike disintegrating, being crushed. And hauntingly, the same is happening now. Independent bodies, including Amnesty International and the UN Refugee Agency, have reported that conditions of detention in PNG are cruel and degrading and amount to arbitrary and unlawful detention. The degradation is so deep that women and children detained there were recently flown back to Australia. Now, how did we arrive at this point? With the revival of offshore processing in Australia in August last year, the protections introduced by Parliament in 2001 have been abandoned by Parliament. New laws based on past bills were urgently passed in a mood which evoked the frenzied temper of the Tampa period. These laws have effectively stripped bare stripped the statute bare of the protections which had been interpreted by the High Court to prevent expulsion of asylum seekers to places without fundamental protections backed by law. So now, when deciding to expel asylum seekers abroad, the Minister does not have to consider the availability of international human rights or domestic law protections in the other country because they are not necessarily relevant. The statute overtly says so now. It says the Minister need not look at this issue. The rules of natural justice are expressly ousted, and in fact, the only condition expressly imposed upon the exercise of the power, the only limit, if you like, is whether the Minister considers the transfer to be in the national interest. Whatever that may mean, whenever in our nation's political life that question arises. It hands to the Minister of the day an almost unlimited power to expel an asylum seeker anywhere, at any time, without having to consider what would happen to them. As if the Refugees Convention comes with an on, off or pause button and Parliament can just press pause. The concern here is not with the engagement by the Executive and Parliament in one of its clearly legitimate and necessary functions, that of lawmaking. The concern is the nature of the law, of the very nature of the laws that have been made. And that is that to circumvent the High Court's ruling, it's been considered necessary to all but remove the role of the courts and thus the ordinary operation of the rule of law, to take the law out of the law. Now we have laws where, on one view, the Executive may decide for itself whether it's applying the responsibilities to refugees, which it appears to still accept it has. Just trust us, it says. The laws may all but excise independent scrutiny by the courts of the substance of the arrangements, the expulsion of people in peril from our territory elsewhere. And our compliance with the Refugees Convention may be conditional upon the national interest. Our international obligations under the Refugees Convention and other human rights treaties become vulnerable to subversion by the so-called national interest. The national interest is not necessarily informed by human rights obligations. Instead, the national interest informs the extent to which we are prepared to comply with those fundamental obligations at any given time. Executive action is freed from the ordinary accountability and independent scrutiny under fundamental principles of law. We then, as a nation, I think, must ask ourselves the question, how can it be in the national interest to act contrary to laws protecting human rights under treaty obligations, and in doing so, condemn people, consciously condemn people fleeing from harm to what may well be a life of anguish and suffering? Now, what does all this amount to? And it's here that I want to bring us back to the big overarching theme, the common thread in our 4 High Court cases and across the legal landscape more generally. An overarching characteristic of immigration law and policy in the last decade and a half has been, in my view, a radical deviation from the ordinary legal principles, the golden threads of the Australian legal system, such as access to the law, access to lawyers, to the courts, to habeas corpus, anti-discrimination, and the rule of law. It's also often been accompanied by abrogation of international human rights obligations. Within this terrain, an ever-deepening tension has emerged between the executive and judiciary about who makes decisions and how those decisions are made, about the power of the executive and the constraints on this power on 2 core issues. 1, individual liberty, and 2, decision-making powers. There has been a persistent pattern of governments fiercely resisting scrutiny by the judiciary and seeking to impose policy-based decision-making schemes which operate outside the fiat of which operate on executive fiat and outside the reach of the law. In Australian policy, the treatment of asylum seekers and refugees has involved, I think, a unique and dramatic interaction of international human rights law and Australian domestic law. Although the conventional theory goes that international law must be clearly incorporated into statute for it to have force here, I think what we've seen is a far more complex interaction and tension between the three sources of law at play: international human rights, Australian legislation, and the common law. The PNG plan appears to constitute a clear-cut, flagrant violation of our obligations under the Refugees Convention, and most obviously, but not only, in its discriminatory and punitive treatment of people due to their unauthorised arrival by boat, and in proposing to send them to Papua New Guinea and the attendant dangers and lack of protection in law and on the ground there. Whether it breaches Australian law raises a separate, but not entirely unrelated, set of questions, which brings us back to the complex interaction and tension between international and domestic law. Given recent legal history, there is every likelihood that this will be a matter for the courts to consider again. The outcome may be less certain. A stark example of this overall pattern is the plight of Ranjini and more than 50 other refugees who have been incarcerated indefinitely, and in some cases for over 4 years, on the basis of secret security assessments in which they have not been told the specifics on why they've been deemed a risk. People who are at risk of persecution in their homeland, people who have been held without charge, trial or conviction, and yet are condemned to a cruel and inhuman Kafkaesque twilight world. They don't know the case against them, they can't defend themselves, and they don't know when, if ever, they will be freed from detention. Now, the core problem is the decision by the government to maintain an unconditional and unassailable link between the security risk assessment and that person's liberty. Other comparable countries like the UK and Canada do not do this. The link is severed there, and people deemed to pose a risk live in the community under tailored conditions. Ordinarily, we think of the practice of prolonged detention without trial. Ordinarily, when we think of the practice, I beg your pardon, of prolonged detention without trial, we think of tyranny and we think of dictatorship. We do not think of it happening to more than 30 men just a few kilometres up the road in the suburbs of Melbourne. Now, this pattern is perpetuated by the government's response to the M47 case last year. The government conceded the need for an open and accountable process for review of ASIO security assessments for refugees, but has announced a new review system which is anything but that. The inherent weakness of the process is that it is not set in law, and ASIO is not bound to follow the reviewer's recommendations. The lack of external scrutiny with the force of law on matters which so gravely affect a person's liberty is, in my view, extraordinary and disturbing. It means that the reviewer reviews ASIO's conduct under powers prescribed by law under a process outside the law, with no reviewability. It also means that if the reviewer says ASIO got it wrong and the person's not in fact a security risk, ASIO could ignore this and a person could be left locked up indefinitely without having been charged, tried or convicted, and without legal redress. So in light of this current executive trend to oust independent scrutiny of the rule of law on questions as grave as freedom from unlimited incarceration, and in the absence of a federal human rights charter or a constitution with any more than a mere smattering of enforceable rights, the question arises, what can be done? Is there anything left in the law to protect an individual's liberty? The principle of legality is one source of protection, and a potentially potent one at that. It is said to be a unifying concept encompassing centuries of common law jurisprudence, and at its heart lies the idea that, in the words of Chief Justice French of the High Court, and I quote, "The rule of law posits legality as an essential presupposition for political liberty, and the presumption that Parliament did not intend to invade fundamental rights, freedoms and immunities, or to interfere with rights such as access to the courts, procedural fairness, or equality of religion or liberty." Courts interpret statutes on the assumption that it was not intended to trample fundamental rights or freedoms. And in the absence of a Bill of Rights, I think we have recently witnessed the development of fundamental rights through this principle. As it develops, the protective scope of the principle is unclear, but it may hold a key to the protection of the rights and freedoms and dignity of even the most apparently unpopular of individuals or causes. Returning to M47, our recent High Court security case, we may have seen the potential for further development of the principle of legality. By reference to the principle of legality, Justices Gummow and Bell held that indefinite detention was not permitted in the absence of clear authorisation by Parliament. To give a brief example, Justice Bell affirmed the fundamental nature of the right to personal liberty was not confined to Australian citizens, and that the 2004 High Court judgment of El-Khatib, which found by majority that it was lawful to lock up an asylum seeker indefinitely, was weakened by its failure to refer to the principle of legality and the presumption of liberty it bestows. Therefore, the principle of legality was again affirmed as part of the constitutional relationship between the courts and Parliament as an aspect of the rule of law. Now, ultimately, the majority of the court decided that it was not necessary to determine whether it was lawful to detain a refugee indefinitely because of their invalidation of a regulation which in effect gave ASIO a self-executing power to deny the grant of a visa to a person and to deny them their freedom. So as it now stands, 50 refugees remain indefinitely incarcerated. One of those refugees, our client, is Ranjini. She recently issued a High Court challenge to her detention. One of the key questions before the court is the role of the principle of legality in resolving whether she, as a mother of three, who has been found to be a refugee and needed protection and assessed as a security risk, can be detained by the government apparently indefinitely and possibly forever. And whether Australian law puts a different value on liberty for non-citizens, one where liberty is more easily put in jeopardy. Now, why does this matter? Not only because we have agreed with the international community to comply as a wealthy nation, and as a wealthy nation we're well placed to do so, but because these laws and the principles underpinning them have been painstakingly designed to provide real protection to people in their daily lives. It's not about legal niceties which can be dismissed as inconvenient or outdated in more trying times, because as soon as we press the pause button on our legal obligations, we jeopardise the safety of the very people that the laws are designed to protect. The law, and human rights law, is of course deeply rooted in ethics, and we must confront the ethical dimension of these commitments. The current policy of Pacific Solution Mark II and its latest incarnation with the PNG plan is consciously harming people fleeing from harm, purportedly in the name of stopping the boats, protecting our borders, breaking the business models of people smugglers, and/or saving lives at sea. This squarely raises the key ethical question: whether we may or even should do something awful to achieve a good outcome, or does the end justify the means? Now, in my judgment, to condemn people to unnecessary and inevitable abuse is completely unjustifiable. Asylum seekers, refugees, will endure the agony of uncertainty without the prospect of timely due process. They'll be stripped of their liberty and be kept separated from their family and a safe and secure future. It is not, as has been asserted by some, a necessity to do this. It is a conscious choice, and the logic underpinning this choice of deterrence policy is brutal. The more painful the penalty, the more effective the policy. Under this logic, it is suddenly acceptable, if not necessary, to expel a child to a country like PNG, where detention is degrading and there are no guarantees to guard against further harm or abuse, all in order to deter others from coming. So what should guide our approach to refugee policy? In his 2003 quarterly essay called Sending Them Home, Robert Manne offered reasons for why we should take in and help these people who arrive on our shores rather than expelling them. He described it as the ethics of proximity, the essence of which is the moral imperative created by the presence of the person on our doorstep, and akin, I guess, to the Good Samaritan principle. Drawing upon this idea, I would like to propose another expanded idea with similar strands about what should guide our approach to refugee policy, which I would like to call the ethics of protection. The ethics of protection recognises the necessary and close interrelationship between core legal, moral and practical dimensions of protection and the need to draw them together, to fuse them. It requires that policies be based on protecting, not punishing people, promoting human dignity, not abusing it, and that in action we must protect those on our doorstep, not shut the door in their face. That we must take steps to minimise harm, not steps which compound it. The ethics of protection also recognises the special importance of the context here, that we are responding to the needs of vulnerable people fleeing from harm and must ensure that what we do contributes to restoration and rebuilding of people's lives, not exacerbation of harm. Why? Because it's what we've committed to do by law, laws and commitments which directly reflect what is morally acceptable treatment and which are carefully constructed to protect rather than further punish people in practice. Now, in closing, I want to bring us back to our recent past. And it seems that there are at least two 20th anniversaries of profound significance in the nation's history that have just passed. One, a beacon bright, where the law found a fair go for Indigenous people, Mabo. The other is the introduction of mandatory indefinite detention of asylum seekers who arrive here informally, surely one of the darker anniversaries this country has had to mark. After 20 years of systematically incarcerating large numbers of women, children and grown men alike, people who have committed no crime and who in fact have often fled from terrible crimes against their human rights, we are in serious danger of accepting and institutionalising a practice which betrays what for centuries has been a fundamental tenet of life under the rule of law, habeas corpus and individual liberty. Why is it that we have become inured to this, so that we have come to accept, without the nation flinching, a situation where it is the norm to lock up innocent people who pose no harm and to often destroy them in pursuit of policy or political imperatives of the day? As shocking as this may seem, there has been no serious revolt in the body politic or the public. Now, alongside life, liberty is one of the most precious and fundamental rights and values which goes to the very heart of what it is to be human. And the denial of such a fundamental right, that of liberty, through indefinite detention has, in my view, in many ways shaped our response to asylum seekers over the last 2 decades, a response which constitutes the harshest and most comprehensive anti-asylum seeker system in the Western world. The PNG plan has perhaps become possible, even necessary to some, because of this path. And out of this comes an urgent question for our nation. Are we in the midst of the creation of a new damaged generation of people? People who, having fled from harm, endure a second wave of suffering at the hands of indefinite detention and other punitive policies before becoming Australians. A damaged generation which prompts, as some have suggested, the thought of a prime ministerial apology in 25 years' time. And what are the consequences? Well, this question recalls the comments in A's case in the House of Lords, a case where 9 foreign men were incarcerated without charge under anti-terrorism laws, in which Lord Hoffman stated, and I quote, "The real threat to the life of the nation, in the sense of a people living in accordance with its traditional laws and political values, comes not from terrorism, but from laws such as these." We must never forget the real cost of this, the real face of this. Ranjini, refugee and mother of 3 who remains indefinitely detained on the basis of a secret security assessment without trial, and possibly for the rest of her life, with her Australian resident and citizen children living with her in detention as visitors. The fate of mothers, children and fathers alike who under the PNG plan may be forced to live in permanent separation, unlike the family who narrowly escaped this fate under the Malaysian solution. And the man who brought the recent High Court security case. He's a man who is known by an initial and a number, M47. He is also a man with a heartbeat, and he is a man who is suffering. And this is what he wrote to me from detention, where he has been held for over 3.5 years. My feelings are dead. I have my body and my soul only. All my parts of the body are now stopped working properly. Hearing, looking, tasting, and all feelings are gone, and I am living without anything. To my mind, the real challenge is not the next High Court case. The real challenge is how our country can find its way back on treatment toward refugees. That is, to honouring our commitments under law, honouring the values which underpin them, and honouring the well-being of one another as fellow human beings of equal and precious worth. Otherwise, we also risk putting in jeopardy the kind of society that we want to live in and defend. Thank you.